Hello, everyone. Welcome to Save News TV. I am your host, AZ Hubbard. Thank you for letting me into your homes today. And we are going to probably have at least two videos out today. So make sure you like, share, and subscribe. Hit the notification bell. We're pulling up this TD Jakes versus Youngblood. TD Jakes attorneys have replied to the show cause response from Youngblood's attorney regarding the sanctions. It was done late, but today is the day they're supposed to be in court. So I probably will be back later today with another video. Um, regarding this, but right now we're going to read the response from TD Jakes' attorney. I will be commenting in the middle of everything. Like I said, this is going to be a heavy upload day, so make sure you have on your notifications. So without further ado, let's get into it. TD Jakes' lawyer said, "Oh, hold the phone. We are coming to court today tomorrow on the 24th because we want our money. We wants to be paid. Again, we don't have a dog in this fight. We enjoy a good lawsuit. We enjoy um reading it and listening to both sides of the aisle. You can either be Team Jakes or Team Youngblood, doesn't matter, or even in this case, Team Blackburn. But be respectful in the comments. Make sure you like, share, and subscribe because this takes a lot of effort and time to do this and reading. So we want to get this out to other people. Again, turn on your notifications because we will be coming back as they are in court today. And so we're going to get this one out early. All right. So, um, declaration from Dustin Posh regarding the burden of responding to the brief permeated by gross misrepresentation and fabricated authority and Blackburn's vexatious conduct. Now, David Pulsh is TD Jakes' attorney, and he is replying to this and letting the judge know this you definitely need to sanction Blackburn. These are the reasons why, and this is how much it's costing us. Yesterday, I said it probably will cost between $50,000 to $100,000. I want you all to put your estimate in the comment section. Now, this was before we reading this today, so the number might be even higher as the cost. So put your estimate down as we go on how much this is going to cost Blackburn if the judge rules in his favor, in TD Jakes' favor. Um, David Pulsh. One, I submit the declaration regarding the conduct of the defendant's counsel, Tyrone Blackburn, imposed on plaintiff, which it may find useful when evaluating Blackburn's response to the court. So here he puts out his table of contents, and we are not going to go over every table of contents because we're reading every section. Blackburn tactics impose a significant burden on the plaintiff, driving up costs astronomically because his briefs were premeditated permeated with fabrications. Blackburn's tactics forced plaintiff's counsel to spend an extraordinary amount of time and therefore plaintiff an extraordinary amount of money. Okay, so there you go. They coming in for the unaliving as far as Blackburn's finances. They want his pockets. They want his money. And they're going to argue in this brief as to why they should receive this money and he should be sanctioned. Opposing the motion's frivolous contentions, and he acted vexatiously throughout, including after being confronted with his misrepresentations. Two, on May 5th, 2025, defendant Youngblood filed a motion to dismiss and memorandum in support. Blackburn was the sole signator and filer of the opening brief. While reviewing and analyzing the opening brief, glaring inaccuracies emerged. Fabricated quotes from the court on April from the April 25th opinion. Fabricated quotes from other cases, misrepresentations of presidents, and misrepresentations, misstatements about complaint. As a result, I, along with other attorneys and legal support staff at my counselor's firms, conducted a detailed manual review of the case law and record citations in the opening brief. Okay, so we already know that the money is going up. The cash register is being hit because he says clearly that not only did he said other attorneys, plural. So, you're racking up hourly attorneys of fees for not just him, but the other attorneys. And he didn't say how many legal support staff. So they racking up money for paralegals, researchers, and other staff at their firm. Okay. So this is going to be a big, humongous bill. That review found that at least 35 district misstatements, many serious and inexplicable, that were spread across 16 of the opening brief's 17 pages, excluding the cover page and preliminary table. A full list of misrepresentations from Blackburn's opening brief and reply is included in the June 17th declaration of Justin Push. 4. Usually responding to a motion to dismiss requires counsel to analyze the legal arguments, review authority, apply those authorities to the facts alleged in the complaint, and prepare an accurate response thereof. However, when the brief was permitted with formatted quotations, fake holdings, non existent rules of law, and mischaracterizations of record, as was the case here, the burden of response becomes exponentially greater. Wow. I mean, they're not holding back. Like I said, TDJ's attorneys, man, they're not holding back. They hitting hard. For example, counsel must conduct even deeper dive into the cited legal authorities to confirm the erroneous circumstances before even considering how to respond. So, in other words, they had to do deep research, running up the tally of how much this is going to cost even before they could even start to respond and write the declaration or motion after that. By submitting pervasiveness and seriously flawed briefs, Blackburn exponentially increased the burden and cost analyzing the arguments to prepare a meaningful opposition. Wow. 5. On May 27th, plaintiff painstakingly noted these errors in his opposition and in the concurrently filed declaration by Dustin Pulse, the latter of which spent 17 pages describing each issue in detail. And the plaintiff had a point of a myriad of issues with the brief. These plaintiffs risk the possibility that the court would be tricked into dismissing his case based on fake authorities, which occurred in a recent Georgia case. Moreover, my firm and co-counsel also had to triple check all of the identified errors to make sure we were correct before lodging serious accusations against Blackburn, an obligation that was not reciprocated. Okay, so now we're looking at, as far as we trying to tally up the cost of this. He said, okay, we had to first check. Then we had to, now these are the attorney fees, all those fees we discussed. We had to check. Then we had to double check. And now, even more so, before we even, respond, we had to triple check. So, whatever the costs were initially on the first check, Just multiply that by 3. So, like I said, my guesstimate was 50 to $100,000. It might be way above that. So again, I want you all to, um, as you like, sharing, and subscribing, put your estimate in the comment section. 2, the plaintiff raised these issues. Blackburn only acted more vexatiously. Af 6, after filing the opposition, plaintiff's counsel fully expected the defense counsel would be mea culpa and withdraw the false representations or otherwise correct the record, or at the bare minimum, explain how the filing could be littered with misrepresentation. Not Blackburn. Now, they love to put that, not Blackburn. They did this other thing. On June 2nd, he filed his reply, which, to our dismay, doubled down, inaccurately quoting cases, misrepresenting holdings and rulings, and misstating the record. July 17th. Blackburn also went on the offensive against plaintiff's counsel, claiming that he had discovered a quote pattern unquote of issues with the citation in plaintiff's opposition, including at least 20 incorrect quotations. As the court has as the court already determined, this is utterly false. 7. On June 4th, plaintiff seeking to address Blackburn's latest misrepresentation emailed him to ask whether defendant would consent to a motion to leave the file a reply to respond to these newly raised and materially false attacks. Blackburn wrote back, quote, I do not consent, unquote. Woo! Okay. You will not get a second bite of the apple. We're not, end quote. You will not get a second bite of the apple. Instead of proving your client's baseless lawsuit has merit, which it does not, you weirdly spent your time focusing on yours truly, end quote. Blackburn was talking that mess to them while he was busy being on the wrong end of history, okay? On the wrong side of history. He was busy talking that talk, writing that mess. In fact, as the court has recognized, there was plenty of reason to focus on the counsel's conduct and briefly was preeminated with fabrications, misstatements, and outright lies, which have driven up the cost of the litigation expeditiously. The conduct was shocking and its gravity was readily apparent. This court therefore granted the motion for leave and the plaintiff filed his reply on June 5th. Number 8, because Mr. Blackburn ignored the extremely serious issues raised in the opposition and supply and continued to assert his conduct had been entirely proper. Plaintiff was forced to prepare a Rule 11 motion. Now, that Rule 11 motion is, hey, we need to sanction this person. We need to sanction this man. Safe harbor provision. This step, which should never have been necessary, imposed even more attorneys and fees on the plaintiff, make greater the magnitude of his misrepresentation. So, in other words, they're saying, look, all of this could have been avoided, but all of by what he's doing, it has doubled the price. It costs even more, at least double the price. So, man, whew. 9, after I served the Rule 11 letter and the motion on Blackburn copying the counsel of record on June 17th, we heard nothing from Blackburn. He never responded. But now he claims that Rule 11 letter prepared a significant cost to plaintiff was what finally inspired him to consider correcting the issues. But his response to the OSC makes clear that he was not in the process of correcting his blatant and inexcusable errors. Instead, he was rebriefing the motion to dismiss and planned to file it anew, citing new cases and thereby forcing plaintiff, who had already spent too much time and money dealing with this chockery, to respond to yet another disposition motion. It is not withdrawal as contemplated by Rule 11, nor is it any acknowledgement of errors of his ways. Frankly, Blackburn's claim that he was trying to correct the record rings hollow and is beveled by the record before this court. Okay, they are not playing with Blackburn, buddy. You getting ready to pay some money, and they are done with your craziness, your cray cray. Okay, according to them, that's pretty much the assessment of this. This is going to be a very expensive lesson. So, yeah. Number 3, Blackburn's track record of similar conduct both undermines his explanations and suggests he will not be deterred. 11. Paragraph 1 of Blackburn's declaration statement states, quote, I have practiced law since 2018, and during that time, I have never encountered citation or quotation issues in any legal filings submitted to the court. This is the first instance of its kind in my professional career. I have always respected the court. This is the first instance of its kind in my professional career. I have always respected the significance of Rule 11 and the duty it imposes on attorneys to ensure the accuracy, factual foundation, and legal grounding of each filing. That is, end quote. That is false. As of May 27th and June 17th, Pulse Declaration explains in more detail this is not Blackburn's first rodeo. Other federal judges have been sharply critical of his Rule 11 compliance and have issued warnings and grievance committee referrals for similar conduct. 12. In just one example, less than 2 months before Blackburn signed and filed the opening brief, he received a warning to counsel from another federal district judge, which wrote, Tyrone Blackburn filing are replete with inaccurate statements of law, and found that it was not just disturbing but shocking that any licensed member of the bar would espouse such an absurd understanding. And this was in the Jones versus Combs case in March of 2025. Number 13. And when appearing on Larry Reed Live, the very YouTube show that issue in this litigation, to discuss the case in January, Mr. Blackburn expressed that he does not care about the threat of sanctions and that it instead emboldens him. He said, I don't give a D what anyone says about me. My skin is thick. I would not be able to do the work that I'm doing if I cared about people's opinion, and that's okay. I have had all kinds of people file all kinds of BS sanctions motions and all kinds of crap against me. You know, saying all these things. I don't care because when you attack me, I know that I am close to the head of the snake. So I'm going to keep going. So to go harder you come. So the harder you come, the harder I'm going to come and trust and believe. I'm not going to stop. Woo! If TD Jake's attorneys isn't using Blackburn's own words against him, kid you not. They are not playing with him and they are using his own words against him. And of all places that he would say this is the Larry Reed live show. This is insane. This is funny. 14. Although Blackburn has expressed disdain to Rule 11, he has also baselessly threatened to seek sanctions against plaintiff's counsel. Indeed, in Blackburn's very first communication with counsel in this case, in response to an email asking him whether the defendant would waive service, he twice threatened plaintiff's counsel with sanctions while also erroneously citing an inappropriate case for the proposition that the defendant's statements fall squarely within the ambit of Pennsylvania anti-SLAPP law. And in other email regarding the same issue, Blackburn threatened to go, quote, scorch earth, unquote, if the plaintiff did not agree to mediate this case. Woo, okay. So he said he was going to go scorch earth. Woo, baby, woo. Further, in his declaration, Blackburn claimed he completed several CLEs about AI, but submits no documentation of his attendance. Woo. He further claims that, quote, I have since conducted a thorough audit of all active case filings generated using these upgraded subscriptions and have begun correcting any citation and formatting errors identified through the audit, unquote. But my associate has reviewed the dockets for many of Blackburn's open cases and has not identified such filings, nor has Blackburn identified them in his declaration. Baby, Blackburn is getting ready to pay. TD Jakes' attorneys are all about that research, okay? They have not only researched the case here, they went back and research all of Blackburn's open cases. You know as well as I know that that cash register just went up. For them to have researched all of those cases, that goes into the cost of the proposed sanctions amount because they had to research it because he put it in his show cause, so they had to either prove or disprove it. So I'm telling you, I might be a little low with the $50 to $100,000. We might need to tick that cost up to $100 to $150,000. What do you all think? Put it in the comment section. It might be more. I might still be low. I still might be low. Blackburn's OCS response continued the same pattern, offering confusing explanations and making further false statements. Blackburn's OCS response filed a day late. Remember we were talking about this day for yesterday that he filed a day late and hopefully not a dollar short? Baby, that dollar short is many a dollars. It's many a dollars. May initially appear to in some ways to be mea culpa, but Blackburn fails to address several erroneous misrepresentations, ignoring how he doubled down instead of correcting the record after plaintiff's May 27 opposition noted the issues and how he made false misconduct allegations against plaintiff in reply. On those points, He offers no explanation at all, a tack that suggests, at least to me, that he does not appreciate the gravity of his conduct. And the explanations he offers are vague, contradictory, or seemingly false, as explained more fully below. We don't have a dog in this fight. But I'm telling you, from reading the last few filings, it seems, and nothing is proven until the judge rules. Everything is based on the judge rules. But just by these filings, um, Blackburn is losing bad. He down bad. He down bad, everybody. He down bad. Blackburn's response further misrepresent the court's April 2015 opinion, 25th opinion. Most outrageously, Blackburn's OCS response misrepresents the court's April 25th opinion yet again, stating that the opening brief paraphrased language from the opinion as though it were quoted verbatim, and apologizes only for giving the appearance of misrepresenting the court's ruling. Nonsense! As the court and the plaintiff have noted in filings which Blackburn purports to have seen, not only does Blackburn attribute statements to the court that does not exist, but he also twists the court's prior opinion beyond recognition. The court made no such finding in the memorandum opinion. There is nothing in the court's opinion that would reasonably be construed as standing for such contentions. In that opinion, the court expressly refused to address the sufficiency of the complaint. Baby, baby, Blackburn is definitely on the ropes. They got him on the ropes. They got him on the ropes. At least one case was completely hallucinated. Not hallucinated. Not hallucinated. These attorneys are dragging Blackburn for filth. For filth. That's why I love reading these cases, because these attorneys and their writings, man, it shows the attorneys um personality, their style of writing, whether or not, um, it's like a verbal boxing match. Okay. Okay. So at least one of the cases was completely hallucinated, which undercuts Blackburn's explanation. Blackburn tried to explain away the fake quotations and miscitations as arising from an AI platform mixed up with fact patterns of a very real cases used to generate the brief. That contention has many flaws, the most glaring of which is the fact that the reply include one completely fabricated case. So in other words, he said Chat GTP. That's not LexisNexis. That's Chat GTP. On page 5, the reply cites a case styled Jackson versus Lehigh for the same proposition noted in the preceding paragraph, but the entire case appears to have been fabricated. The reporter cites corresponds to an appeal of criminal sentence, United States versus Lindesma Nolesco, corresponds to another case, Kendall versus the government of Virgin Island. And while the Third Circuit has heard other cases involving the Lehigh Valley Hospital, such as Angelico versus Lehigh Hospital and Caller versus Lehigh Hospital. None are relevant to the defendant's opposition. As far as we can tell, and our research has shown, in other words, they said, not just this is not just our opinion. We have researched this and we want our money back for this research. Uh, no case called Jackson versus Lehigh Hospital exists in the Third Circuit or anywhere else. And yet, Blackburn does not take back or acknowledge the manufactured citation. Blackburn's explanation on how this issue arose are both confusing and contrary when the moment the court demanded clarity and candor. Blackburn admits that there were errors in the brief, but minimizes them throughout, blaming both Lexis and Westlaw for the issues and claiming the formatting and tagging mechanisms of these modernized legal research tools created artifacts. He says that he misinterpreted how these tools handled paraphrased text and inserted quotation marks, and failed to independently confirm that the quoted formatting match the underlying source material in every instance. But to me, these explanations appear to be meaningless evasions intended to sanitize the gross fabrications and misrepresentations identified by the court and plaintiffs. Dude, this is not your day, Blackburn. This is not your day. Okay? Not according to this. And elsewhere, Blackburn offers confusing and contradictory accounts of how the hallucinations came about. Look, when in a declaration they tell you that the attorney is hallucinating cases, hallucinating now. That is some serious shade. That's some serious shade. At times, he claims he found the case law and highlighted the section. I researched and wanted to use uploaded those cases and authorities as well as supporting materials with written instructions and upgraded legal research platforms, extracted the information and drafted the requested documents. But elsewhere, Blackburn claims that the AI programs generated suggestions and citation fields that I mistakenly incorporated without fully verifying the quotation format and attribution. These explanations contradict each other. In one, Blackburn found and uploaded accurate cases that were then mixed up with legal AI drafted the brief. In the other, legal AI found the citation itself. It can't be both. Oh, the attorney said it can't be both. It can't be both. It cannot be both of these. It's either one or the other. Number 21, Blackburn represents that he started researching cases on May 5th, 2025, and has reviewed nearly 50 cases since that time. But May 5th was the day he filed the opening brief. So even crediting Blackburn's representations about his research, that would mean that no, he did no such research before the day he filed his opening brief. And it would be difficult or impossible to research, identify, and read 23 supposedly on point cases in a single day while also completing a 20-page brief and filing it. Something is amiss. Listen, listen. TD Jakes' attorneys are dragging. They're dragging him. Moreover, he claims that he used LexisNexis protege and Westlaw co-counsel to draft the brief. But of the opening brief, 59 legal citations, excluding duplicates from the legal standard paragraphs repeated twice, there were 33 hallucinations, a 55% inaccuracy rate. Listen. Jake's attorneys are not playing with Blackburn. They want him sanctioned and they want their money. Okay? They want him sanctioned, they want his money. Okay? It is what it is, and they are coming with the facts. Um, they said 33 hallucinations, a 55% inaccuracy rate. That's heavy. That far exceeds the hallucination rate of legal AI products. Negative 17% for Lexus and negative 34% for Westlaw, and is more in line with the general purpose chat box. Woo! There it is. Mic drop. Mic drop. That's a mic drop. They saying that he used Chat GTP. Chat just Chat GTP. Which hallucinates between 58 and 82% of the time in response to legal queries. See Stanford University Center of Human-Centered Artificial Intelligence. AI on trial. Legal models hallucinate in 1 out of 6 or more benchmarking queries. Yet again, Blackburn's excuses do not stand the basic scrutiny. Blackburn's contentions were neither correct nor meritorious, contrary to his completely unsourced assertions. Blackburn describes his motions as meritorious and says the legal foundation of the motion was sound, while only the formatting and attribution process was flawed. But he offers no citations or analysis in support of the supposed merit of his arguments raised in his brief, which were unmoored from both the law and the record, as explained in the plaintiff's opposition. Despite the fact that he raised frivolous arguments in his briefs, he claimed that the statements made by defendant about his own lived experience and religious teachings fall squarely within the protections of the First Amendment and Pennsylvania public expressions protections. These arguments were not manufactured, fabricated, or legal baseless. But these were not his arguments. Instead, Blackburn argued that the plaintiff failed to allege, with regard to defamation, the specific defamatory statements, falsities, actual malice, publication damages, and with regard to conspiracy, argument, and common law practice, malice, while charging plaintiff with impermissible group pleadings, all which were wrong. Okay, I'm going to say it. It seems like not that Tyrone Blackburn need to pay TD Jakes' attorneys for these legal lessons that they are giving him now, because they are schooling Tyrone Blackburn. They schooling him. They schooling him. Woo, let's get back to it. And let's wrap this up because I know the more documents are going to drop today. And if he had arguments that knowingly false, factual statements regarding individuals are immunized by the First Amendment if they related to personal experiences or religious teachings. That would have been frivolous too. The First Amendment does not protect actionable defamation at all. Free Speech Cove Incorporated versus Paxton. Certain traditional categories of speech, such as defamation, have been understood to fall outside the scope of First Amendment. Citations and quotation marks omitted. Blackburn's OSC response also states that, as the court will see from my attachments, I have completed the research and cited misquoted content made from actual cases. They were just misattributed. In support of this claim, Mr. Blackburn appends over 700 pages of cases and other materials without offering any analysis or explanations of their significance, perhaps in hopes that the court will not be impressed or overwhelmed by the volume of paper. But the courts are not required to hunt through the records to construct points for litigation. And even if it has, it will see that Blackburn's random jumble does nothing but provide his legal points were real beyond very basic principles. Many of them were not. For example, Blackburn made up the overarching contention that courts have clarified that general denials or self-serving declarations of this didn't happen and insufficient to establish falsity under the Toby Akbal standard. Nor do courts require the plaintiff to allege an alibi. For under the substantially more demanding anti SLAPP framework, a firm and fair denial suffices. Plaintiff denial of these perjury charges in her declaration provides a sufficient prima facie showing that these accusations are false. Mr. Blackburn also states his commitment to this matter was never driven by financial gain. It is rooted in the genuine belief that the lawsuit was an impermissible attempt to chill the defendant's First Amendment rights. But this lawsuit was filed after he personally sent a letter to plaintiff demanding $6 million settlement of Youngblood's claim. Okay. Woo! We talked about this. We talked about this, the $6 million uh letter. And so, he's talking about he's doing it pro bono, but he's getting a percent. If it is settled, he getting a percentage. Even if you win, he would get a percentage. So it's not true pro bono. Number 28. And as if all these issues arising the Blackburn's motion to dismiss are not enough, the plaintiff has recently become aware of yet another issue. Defendant answer denies making any financial demands of plaintiff, despite the known existence of Blackburn's November 15th, 2024 letter demanding $6 million from the plaintiff. When the plaintiff requested an explanation from the defendant, given that the letter expressly states Youngblood's quote authorized unquote Blackburn to make a $6 million demand, defendant through his other counsel now claims that Youngblood never authorized the letter. Okay. Spicy dicey. So, um, spicy dicey. If the representation is true, it means that Blackburn was making financial demands of plaintiff and threatening to file frivolous litigation without his client's authorization. That circumstance raises yet more grievous concerns about Blackburn's conduct, implicates a possible waiver of privilege. Wow, wow, wow. Mm, mm. He said, "Now, after all of this, I'm getting ready to wrap this up in a nice little bow until we meet on the 24th with in front of the judge so we can get paid." Okay. So let's get to this conclusion so we can move on. Because of the extraordinary burden his conduct imposed, the court determines if the court determines that Blackburn should be sanctioned, we believe that an award of the plaintiff's fees is warranted. In addition to any other sanctions and remedies the court deems appropriate, if the court decides to impose fees, we are prepared to submit whatever documentation the court requires. Pay me my money. That's what they're saying. Pay me my money. I think that's what they're saying. 30. I am a United States citizen over the age of 18 and of sound mind, and make this declaration based on my personal knowledge and review of publicly awarded available information. I am admitted to practice in this court pro hoc vice, and I am a member in good standing of the bars of the District of Columbia and the Commonwealth of Virginia. I am a partner of Meyer Watkins Phillips Polsh LLP, located at this address in Washington, D.C. I declare, under penalty of perjury, that the foregoing is true and correct, and is signed by Dustin Poach. Okay, everybody. Uh, what do you think? You think that the judge is going to sanction Blackburn, and that TD Jakes' attorneys are going to be reimbursed or get their money? I think so. But anyway, I would just go do more commentary on this. But like I said, we know that they are due in court today in front of the judge. Blackburn has to show himself in person. And I'm sure after this filing, we know, we don't know, we can pretty well rest assured that TD Jakes' attorneys will be there, because the attorney said that if TD Jakes' um, lawyers wanted to file and be considered for reimbursement or of the sanctions, if he rules in um their favor, they have to present themselves in court. If not, it would only be Blackburn. But I'm pretty sure that TD Jakes' attorneys will present themselves in court today, and we'll be following up with that. I have to keep a close eye and watch, and when they drop that, I might have to go live. But anyway, I'm not going to hold you. Make sure you like, share, and subscribe. Send this out to everybody. Everybody, this takes a lot of time, and we want to make sure that everybody gets it, because sometimes, um, they be restricting the distribution of this. But anyway, all right, you all have a very blessed day, and we will talk to you later today.